Welcome everyone to this wonderful session entitled Marriage Under Muslim Law, knowing more about it. Under Muslim law, marriage is known as nikah, an Arabic term for the union of two people. In Hindu marriage, marriage is treated as sacrosanct, meaning there are mandate ceremonies and occasions for the validation of marriage. But under Muslim law, marriage is a civil contract. According to Muhammad Justice, marriage among the Muhammadan is not sacrament, but it is purely an civil contract which is solemnized by reciting of the verses from the Quran by the Qazis or any other family members, and the law does not prescribe any mandate ceremonies or occasions. The objective of marriage is to enter into a legalized sexual relationship, to start a family, to give birth to children, to provide a household for the upbringing of virtuous children, to provide care and responsibility to wife and children. The ultimate purpose of marriage is to continue human race and attain mutual love, affection, peace, continence, chastity, etc. Now, what are some of the requirements to enter into a marriage contract? First of all, both the bride and groom should be Muslim. They must have attained the age of puberty, which is generally 15 or 16 years. Both the parties should be of sound mind. They should not be in a prohibited relationship as prescribed by the Islamic laws. They should freely consent to marry one another. There should be a marriage officer appointed for the registration of marriage, which is done according to the provision of Muslim Marriage Act. Now, for the consent of the marriage, which is regarded as an important aspect in a Muslim Marriage Act, first of all, consent should be free will. It should not be taken with fear or undue influence or fraud. The consent of measure is valid, whereas in term of minor, it should be given by the guardian, which is jabr. They generally include the father, the brothers, the mother, or the grandmother according to the hierarchy. The consent may be express or implied. Implied consent may include smiling, laughter, or simply remaining silent. If the consent is obtained on basis of mistake of fact, then the marriage will be invalid. If the marriage is done, if the consent is obtained by fraud, then the marriage is void and the father's consent is not substitute for the girl's consent. In a case law, a Syria girl whose consent was given by the father's consent, the court held that the marriage of that girl is invalid. The legal formalities of marriage under Muslim law. Since Muslim law regard marriage as a civil contract, there should be a proposal, ijab made by one party, then there must be an acceptance, kabul done by another party, there must be a consideration in terms of dawar, then the transaction that is ijab and kabul should be completed in one meeting, it should not be delayed. Then the proposal and acceptance should be done in presence of a witness, that is two male witness or one male witness and two female witness. Generally witness is required in Sunni law and it is not required in Shia law. Sunni and Shia are two sects within the Muslim community. Then there is no form of writing or any religious ceremony required. The words used in proposal and acceptance must be clear and equivocal, and they should convey the intention of marriage. And the words should be reciprocal, that is, acceptance should be given for the exact proposal made. There are some marriages which are prohibited under Muslim laws. These prohibitions are classified into two types: absolute prohibition and relative prohibition. Absolute prohibitions are marriages done with blood relatives. These marriages are rendered Void, they include kurabat, that is marriage with blood relationships such as mother, grandmother, sister, granddaughter, niece, etc. Musharat, that is marriage with certain close relationships such as wife's mother, daughter, or wife of father, or wife of son, etc. Rija, that is a man cannot marry his foster mother or foster sister. Here, foster mother includes the woman that from which from whom the man has breastfeeded. Relative prohibitions are those prohibitions which occur due to some obstruction in the requirement of the marriage. Such marriages are irregular in Sunni laws but void in Shia laws. The grounds for relative prohibitions are when marriage with two women which are related with each other by degree of consanguinity, affinity of fosterage, marrying a fifth wife, as Muslim law only allowed keeping four wives, fifth wife is prohibited. Marriage in absence of a witness for Sunni laws, marriage with idolatress or fire worshipper, that is those women who worship the idol or fire worshipper. For example, Hindus, the Sunnis can marry women from another religions which originate from Kitaba, that is from books such as Christianity or Jew, etc. Then a marriage with woman during her iddat period. Iddat period is the seclusion of woman after divorce. Let us discuss the types of marriage. First of all is Sahi Nikah or valid marriage. Sahi means right or correct. This marriage occurs when all the legal requirements are fulfilled and there are no prohibition. The effect of such marriages are cohabitation of husband and wife becomes lawful. Children out of such marriage are legitimate and have inheritance right. Similarly, both husband and wife have mutual inheritance rights. That is, when husband dies, wife inherited his property and vice versa. Prohibited relationship are established between the spouse. Now, second is the batil nikah, void marriage. Batil means void. Such marriages are void ab initio. They are not recognized under the law. The batil marriage occur when any of the requirement under the Muslim law is not fulfilled. Children born out of such marriages are illegitimate and have no inheritance right. The wife, after the divorce, loses the right to maintenance. The common ground for void marriages are lack of free consent, incapabilities of the parties, and all the prohibited marriages which we had discussed earlier are void for the Shia sect. The third form of marriage is fasid nikah or irregular marriage. Fasid nikah or irregular marriage occurs when there is any irregularities or defects in the marriage. Such marriages are voidable, but they are not unlawful. Such marriages can be made valid by removing the defect or irregularities. The fasid marriage only exist in the Sunni sect. They are considered void in Shia laws. The grounds for the fasid nikah are same as the relative prohibitions of marriage as discussed earlier. Now, the fourth is the mutta marriage. Mutta marriage are temporary marriage. They are practiced by the Shia communities. Sunni communities regard this practice as unlawful. Then this marriage occurs for a fixed duration on specified terms. The duration and specified terms and dower must be agreed by the bride after the agreed upon period by the parties are finished, then the marriage automatically gets dissolved without the requirement for a divorce. Now, talking about the divorce, there are two types of divorce that occurs in Muslim marriage. There are extrajudicial and judicial. Extrajudicial are dealt by the schools of the Muslim laws, whereas judicial are dealt by the court. Extrajudicial, the divorce can be initiated by husband, it can be by wife, or through mutual mm, agreement from both husband and wife. By husband, the divorce is of three types. They are talaq, talaq-e-sunnat, and talaq-e-biddat. Talaq-e-sunnat is the most proper type of divorce agreement recognized under the Muslim law. Talaq-e-biddat is triple talaq, which the court has declared void. Now, illa is the divorce when the husband abstains from any type of sexual contact with wife for a specified period of time. Zahir Zahir is done when a man compares his wife with the female within a prohibited dairy such as mother or sister. Then the wife can initiate the divorce. Now, by wife, it is known as talaq-e-tafweez and lian. Talaq-e-tafweez refers to the power to initiate the divorce is delegated from the husband. Now, mutual divorce, it occurs by two-way, kula and mubarak. In kula, there is an offer made and due consideration paid. In mubarak, there is no offer and consideration required. Both the parties can initiate and divorce on mutual grounds. Now, the judicial ground is Dissolution of Muslim Marriage Act 1939. This divorce is initiated by wife on grounds of cruelty, abandonment, desertion, etc. Thank you all for joining this session. Bye.